Members of the military are at risk of losing their careers, their livelihood, for behavior that is often not even a crime in the civilian system. That's why you need to know the facts. You need to know your options, and you need the help of experts when facing military justice.
Welcome to Military Justice. I'm your host, Jim Buchanan. Our guest today is Jonathan Crisp, who is an attorney specializing in military law at Chrisman Associates. Welcome, Jonathan.
Good afternoon, Jim.
All right, the term court-martial, obviously very serious. So what is the significance of a court-martial, and then what's the process after someone is convicted?
First thing is it is a criminal trial that the military puts on. It's what we call a criminal trial or criminal process. And if an individual is convicted at that, they now have a criminal conviction. And it is not only in their military record, but it's a civilian conviction. It is not a felony or a misdemeanor. The military doesn't make that distinction in terms of convictions in a military setting. They call it a federal conviction. So immediately after that process, you have what's called an RCM 1105 review, or can submit matters under Rules for Courts Martial 1105 to the same commander that just convened the actual court-martial. That's your first chance for what we call clemency, asking the convening authority to take certain action in your case. And there's a whole range of things that he or she can potentially do.
So then after the 1105, I mean, what comes next after that?
That is all dependent upon the sentence. So you're going to get either an Article 69 review, or you're going to get an appeal to the service court. So there's the Army Court of Criminal Appeals, the Navy Marine Corps Court of Criminal Appeals, Air Force Court, and so on. It's dictated by the severity of the sentence. So any sentence that does not contain a punitive discharge or confinement in excess of a year, you're going to get an Article 69 review. Conversely, if the sentence does contain a punitive discharge or confinement for in excess of a year, then you're going to get an automatic appeal right to the service court.
So then why is there a difference in that appellate review?
Sure. The biggest distinction is your loss of due process and the freedom, liberty interests that are at stake. So the Army, the Navy, Congress really has dictated that if you didn't get a punitive discharge, or you're not facing what they deem to be a significant jail sentence, that you're not going to get as much appellate review. So an Article 69 review is an attorney who sits at the Judge Advocate General's office of the respective branch and reviews the sufficiency of the evidence and does what we would call a legal review. And you have an option to either get a rehearing if that attorney decides that you are deserving of one, or they can dismiss charges. There are limited timelines in which to submit an Article 69 appeal, but it's a distinctly different review process than you're going to get at a service court. So for example, at a service court, you're actually going to be in front of a panel of judges. You're going to submit briefs. There's going to be oral arguments between defense counsel and government counsel. So it's a much more robust review process, shall we say.
Yeah, so what else should service members know about that process in review?
What they're going to want to know and understand is what they can present at the different review processes, the timelines that kick in. So you have no more than 3 years to do an Article 69 appeal. And in a CCA appeal or criminal court appeal, it's automatically triggered. You're going to get an automatic right to counsel for a CCA appeal through the military, and then you can hire a civilian attorney in that review process. Similarly, you can hire and should hire a civilian attorney in the Article 69 realm who has done a number of these. These are just as important. Just because the sentence doesn't contain a punitive discharge, it's still a criminal conviction, and it's still a significant event in any individual's life.
Well, share with us what kind of experience Chrisman Associates has with appealing these kind of calls.
For 20 years, we've been doing this, both in uniform and out. Some of our attorneys have served as attorneys at what we call Defense Appellate Division. Each branch has appellate attorneys that solely focus on doing appeals in this process. That experience is invaluable because you not only see it from the perspective of the service member, but now you can go in as a civilian and take a very different tack. The political climate has politicized, or I would say Congress has politicized the appellate process. Anytime you see a negative review, or anytime that a case is overturned, it's potentially subject for congressional commentary. It is much easier, in my opinion, for a civilian attorney to navigate that political minefield and not worry about any repercussions.
Always seek out an experienced attorney.
Yes, sir.
Okay. Jonathan, thanks a lot. That's
Thank
all
you.
the time we have today for Military Justice. If you're interested in learning more about today's topic, go to mymilitarylawyers.com. Remember, you need to know the facts, you need to know your options, and you need the help of experts facing military justice.